Hi, all. Thank you for joining us. I am stoked for this one. This one is right up my alley, my number one love. This is what I do. I'm super excited to have these guys here. I appreciate everybody who joined today, and we're really looking forward to it. And I, again, just can't contain myself. I want to do some introductions here. So I've got a couple of my very favorite people, and I do actually only say that to a few people. Nick Kohan is the founding partner of Kohan and Bablove and has been successfully growing this business since 2016. And I have to say, just on a side note, almost all the people that have done the defense side of work, because Nick has done years and years of defense work, they just have an extra edge to things just a little bit. So I love Nick's perspective that he's going to bring to the show today, to the seminar, and having that background really kind of rounds people out. He's also an OCTLA board member. Welcome, Nick.
Thank you, Tracy.
You're so welcome. Pratik Shah. Pratik, I am going to destroy your partner's name.
Arthur DeGidio. Yeah.
Exactly. So Pratik is a partner. He is the head of the trial team and the director of marketing at an incredibly successful firm that has offices both in LA and in San Diego. He was a deputy district attorney in Sacramento and has tried a ridiculously amount of different types of cases as well. So he brings a lot to the table. He is extremely involved as the president of the South Asian Bar Association and involved in the San Diego Bar Association and many more as well. And Pratik, you just have that ability that when I see you on screen or I meet you, you just have this smile and it just kind of is infectious.
Oh, so, thanks, Tracy.
One of those people that we just love being around.
Thanks, Tracy. And same to you.
Yeah. And so for the few of you that might not know me, I'm Traci KAAS, and I am the president and owner of KAAS Consulting, also author of What You Can Expect When Expecting a Settlement. This is a book free to every one of my plaintiff attorneys. It's really a tool that you can use to give to your clients if there's a reason that I shouldn't be involved, and we'll talk about that throughout the day today. But if the timing's just not right, but yet you really want your client to have an option, this is something for them that you can have. It also has it on e-copy, so you are more than welcome to ask me for a copy, no cost. I will send it to you or send you the link. Also, author of This Is What COVID Did to Me. When I had some time with COVID, I created Case Settlement. It's an attorney reference guide. See, quick and easy, probably a 20-minute read, and this will protect you and your clients as you're doing settlements. So that's enough about me today, but today is a little more unique than some of the other seminars that I've hosted because I really feel that hearing from me isn't that exciting. And of course, then it would sound like self-serving and that kind of thing. But my goal today really is for all kinds of attorneys to really understand how they utilize their settlement planner, when they should utilize the settlement planner. I think it's just a part of a conversation where you get bits and pieces and you're just not quite sure how to hook it all together and, how it works. And so I just thought today I'm going to kind of hand it over to Nick and Pratik to kind of run this with me kind of just throwing in some comments and answering questions. But I thought that you would be better served to hear from them today more than me. So I'm going to kind of hand it over to Pratik and Nick.
Thank you, Tracy.
Yeah, thank you, Tracy. I think, when Pratik and I were talking about this and how to do it, I think the first thing, and I'm going to share my screen here. I know as much as everybody wants to see my background.
Just looks a little windy there, Nick.
I know, right? The first thing I think that's very important is the players, right? So, and I always, whether it's with settlement planning or anything about my cases, I try to understand all the different players involved in the case. And with settlement planning, it's very important to understand this. And also, Tracy gets involved to assist in these relationships. So I'm going to go over some of them. Pratik, feel free to jump in. So, first, you obviously have the claimant, the center, the plaintiff, our clients. what they want, what they need. You also have your office, your needs, the plaintiff's attorney, what you're thinking. On your side of the V, you may have co-counsel, you may have referral attorney. What I think is the most important in just a normal, straightforward case is to understand that your client is going to be talking to people about the financial interests. And what I call it's kind of hangers on. The friend who knows how to do investments and wants to take their money. These people, as we all know, are getting probably the biggest sum of money that they are going to get in their lifetime. And they have all these ideas and people snagging at them. Pratik, why don't you jump in?
Yeah, no, exactly. I was going to say, I think that's a great point. You've got a friend who just got his financial license and wants your client as his first client, or you've got his cousin's aunt is a real estate agent and they're trying to push him into buying a house and doing all these things. And, one thing that we were talking about is that kind of bad advice. Your clients hired you as an advocate to protect them and push for them. I mean, imagine if throughout the case, we've all had clients throughout their cases that are saying, oh, my friend had a case and they got this much and they did this, and how frustrating it is for us when we got to talk to our clients and say, look, your friend's not a lawyer. Your friend who her case was different, or who knows what happened. It's not the same as your case. It's the same thing when it comes to the financial world, because our job doesn't end when the settlement is once we start talking numbers with the defense, right? Our job is to be an advocate for our clients. And exactly what Nick is talking about is absolutely correct. You have to know who are all the potential people that could be involved to make sure that your client is comfortable with the decision they make. And then whatever decision your client makes, obviously it's up to them. It's their money, it's their life. But if we know all the potential players, the outside influences, parents, a trustee, your office, defense office, if we know all the potential players, then we can say, okay, we know what everybody else wants. Well, what do you want, Mr. and Mrs. Plaintiff? And how can we help achieve that goal? And I think this funny picture right here of Traci herding cats is exactly what this is a lot of the job towards the end of the case. We've worked on this case for 3-4 years. And now we're getting to the climax moment where we're in mediation and we're talking big numbers, and our client's like, and we're telling the client, do you want a structure? Do you do this? If that's the first time you're talking about a structure, it's too late. It's too late. You got to bring this up early and get the clients comfortable with these decisions early and let them know that you are looking out for their best financial interest. I mean, none of us, we don't get commissions or anything like that by having them talk to a fiduciary. We don't want it. We just want our clients to be happy, and that in 2 years from now, they don't call us and say, hey, I'm broke. There's nothing we could do for them at that point.
Well, and one of the first questions I ask a new client is almost always, who else is involved in making your decision? And a lot of times I'll have a conversation and then I'll call the attorney and they're like, I never even heard of that person. I've been with this client for 3 years and I've never even heard of that person, or where did that person come from? Or it's an uncle who obviously is a commercial realtor, all kinds of things. But that's when they come in. One of the other things that gets scary for the clients is there's new names, because you've had conversations with them about, oh, we're going to bring in a life care planner, or we're going to have you go to this doctor. But at the end, all of a sudden there's, what is this MSA thing? What is this government benefits person? Who is this trust attorney? So there's just so many more people. There's probably as many, if not more, on certain cases, the catastrophic cases, after a case resolves than before. And it becomes really scary to the client. So particular comment of them knowing who the players are in advance is incredibly helpful. Statistically, all clients are going to listen to they will listen to the advice of the attorney more than anybody else.
The only thing I'd like to add is on the bottom half of this chart, we talk about the defense. It's important to understand the defense attorney, the insurance company, the adjuster, who their settlement broker / planner is. This is not simply a process between you and your settlement planner. You have to get the defense involved. You have to update the settlement agreement. You need to make sure that they know that's coming and how to do that to get this efficient. We all have these cases where we settle them, and then 90 days later, we're still waiting for a check, and we're still waiting for things to get done. This is part of that process.
And I can't tell you, probably an incredibly devastating conversation that the attorney ends up having. And I actually just had it yesterday. It happened yesterday with a client where the attorney did not tell the defense, and this happened for weird circumstances to be an individual that was being sued. And because in the mediation stipulation, which I highly encourage everybody to make sure that they put in there either the mediation stipulation or on an email of acceptance that the plaintiff or plaintiff attorney reserved the right to do a structured settlement, and they didn't. And this particular individual yesterday came back and said, we're not agreeing to it. We don't understand it. I will tell you 100% of the time, that is 100% just ignorance on the other side. Or I have had many cases where the adjuster is just like, if you wanted an annuity, you should have accepted an offer that was, tens of thousands of dollars, or even one case was for $2 million less, I would have done an annuity. And it was Travelers. They do annuities all the time. So sometimes you'll get an adjuster. So it's really important. So Nick, that's a great point, is it has to be done during the settlement process. You cannot receive the money and then do an annuity and have your clients talk to them later. It has to be part of your negotiations or conversations with the defense attorney and or adjuster.
Yeah. So look, we'll get to these kind of best practices, but I just wanted to identify all of these players. So I think, Traci, the next step is, why don't you, I know it and Pratik knows it, but I don't think we know it as well as you. Not all settlement people are the same. What are the various types, and how do they work? And while you're doing that, maybe what are things to be mindful of when we're out in the world and meeting these various different settlement people?
That's a good question, Nick. I think one of the biggest things that attorneys are just unaware of is there are structured settlement brokers. I've been doing this for 16 years, and I do not think I ever saw the word planner or consultant or anything like that until after I started doing it. Now everybody's a planner, but they are annuity brokers. When you're an annuity broker, you have one product. And that's really important to know here, because I strongly believe it's a conflict of interest if you only have one tool in your toolbox and you're having a conversation with a client and the client looks at the planner and says, should I structure that 300 or should I structure the 400? And if the answer to the person that you brought in is that's how they feed their family, how they give that answer is how they feed their family, that's a conflict of interest. So when you're working with somebody or you're interviewing or having a conversation with a settlement planner, ask, are they a licensed financial advisor? Are they a fiduciary? I think that's a big thing that people don't understand. I'm a fiduciary, I'm a securities licensed. That means that I have a legal obligation to always put a plan together in the client's best interest, not my best interest. Whereas when you're an annuity broker and you technically have one product, that's important. Now, just because the world's been changing and I'm excited, I guess, that a lot of people will follow me. A lot of times they'll be like, well, yeah, I'm an annuity broker, but then I refer out to these other financial advisors. I think you guys have all witnessed the disconnect. Again, too many players, too many people. When I put a plan together, I'm assuming I'm the planner for 10 years from now. That is a completely different type of planner that you're working with. And I'm not the only one out there. I'm just saying that if you're working with you need a structured settlement, you need somebody who's doing planning, you really need to be looking for somebody who does structured settlements exclusively, as well as a financial advisor themselves. A lot of times now, the different financial advisors, Morgan Stanley and different advisors, they're like, wait a minute, I want a piece of that action. However, now you have a financial advisor who doesn't understand anything about your settlement documents. You don't have a trusted relationship. You haven't worked with them. They don't actually sometimes have the proper E&O coverage as well. So it gets pretty in depth. And also the other thing is I'm talking right now just about post settlement kind of things. If you're working with a true planner that thinks outside the box, you need to be working with somebody who will do a cost analysis of your life care plan, attend mediations now in Zoom, so that works really well, and actually can help you to work up the case and put more volume on your cases, understanding the Medicare set-asides, those kinds of things. So there's a lot of pitfalls. And so that's kind of one of the biggest differences, is just understanding working with a fiduciary and a full planner that does everything, and brings in the right people. I call it my brain trust, versus just somebody who sells one product. So that's a long-winded answer, but
no, I think that's extremely helpful. There's an old saying, right? To the man with a hammer, everything looks like a nail. And that's the problem sometimes, is if somebody's got one tool in their tool belt, then that's all they can do. And so the big takeaway for me is, I would make sure that our clients are working with fiduciaries, and we do make sure our clients are working with fiduciaries, because just like for my personal planning, and I'm like Nick's and everybody on here who does their own personal planning for their retirement, you're going to use a fiduciary, and for a reason, because they're going to have a wealth of knowledge, a wealth of products that they can look at your personal goals and say, here's what I think is the best plan for you, not just here's what I know how to do and this is what you should do. And that's an important thing. One of the things I wanted to say on what we were talking about earlier is, we want to remove the barriers to settlement. What Traci brought up happens, and it's probably happened to everybody, is that you didn't bring up, you want to do a structure early enough with your client. And now your client rejects the idea, and then later on changes their mind and says, okay, you know what? I talked to my friends and family and I think I want to do it. And then you try to go get the language in there later. And now the insurance has all the leverage, because they can say, no, okay, fine. You got to take $25,000 off the settlement, or, you got to use our guy, or this and that. So you want to talk about these things early with your client, but as well as the defense, and remove those barriers to settlement so everything goes smoothly. So like Nick said, you're not waiting 80, 90 days for a check because you've got to fight over contract language.
Yeah.
One thing that you said that was, super important, is also understanding. I'm pretty sure I can answer this for the two of you. Do either of you guys send your clients to the defense's doctor after the case is over?
Of course not.
Just asking. Just for the simple fact.
Good question.
Yeah, but I mean, constantly I come across attorneys, they're like, oh, you know what? We just use the defense's structured settlement person.
Yeah.
I hear that all the time. And I was in a mediation in San Francisco on Monday, and that's what they do. They're like, we just use the defenses. It's easier. And I'm like, no. Your client you have a responsibility to protect your client. And so it makes no sense. And just so people know, the foundation is, it's very much like a real estate transaction. Is the defense may have their person, and then of course you have your person, and we just work together. And so of course, can one person do the entire transaction? Yes. However, if you were buying a house, do you want to just work with the seller's agent and assume that all of that is right? You want your own representation. So I just wanted to add on to that, Pratik.
What I was going to say, and I think we can move on, and it's a perfect segue, is I can't stress how important it is that I tell my clients that my settlement planner is a fiduciary.
Yeah.
And I explain that to them, what that means in their language. And, the idea, so we all have the broad spectrum of the sophistication of our clients, right? And you have the very sophisticated ones and you have the very unsophisticated ones. The need for a settlement planner is the same regardless of where they fit on this spectrum. But the problem is, I think, well, it doesn't matter. That at both ends of the spectrum, people think they know better, and they're worried about a scam and a conspiracy, and that somehow I'm in cahoots with the settlement planner, or the insurance companies in cahoots with them, or the settlement planner's making money on their money and whatever they want to know. So by explaining that what a fiduciary means, it takes the wind out of that sail, and they understand that, okay, it's a fiduciary, and they can go on their own and look it up on Google or wherever,
Yeah.
figure it out and really understand that you're working on for them. Which I think brings us to the next
Did we
one. And
lose
Pratik,
Nick?
yeah, I will.
Or did you guys
Well,
lose me?
you still there?
Yep.
Pratik, we can
Yeah,
see you.
yeah. I'm here.
All right. What I'll move to the next role is Pratik, and I think it's perfect for you to start on. And what I kind of call the handoff.
Yeah.
What's the lawyer? Why don't you explain the lawyer's role when using a settlement planner? And I think it seems like an obvious answer, but during our discussions and preparation for this, I think we realized it wasn't obvious.
Yeah. You know, the way I look at it is my job as the lawyer and the attorney for my client is to be their advocate, right? We want to get them the best doctors, right? And so we don't do the surgery ourselves. We don't diagnose the client ourselves. We say, look, my job for you is to be your advocate. Let me get you to the best doctor that I know that can do your shoulder surgery, that can do your back surgery, that can give you advice on future treatment. Let me get you to, let me hire an engineer that can go and do the site inspection and tell me what happened there and if there's a code violation, if there's a dangerous condition. And this is part of that process. Just like we would hire experts for other areas, we want to be an advocate for our client and tell our clients, look, you're going to come into a large sum of money, and this money could, depending on the amount, it could last you a lifetime, or it could last you a year. And one of my mentors, when I was coming up in learning how to litigate and do all these things, he told me about a client of his. The client got over $1 million and didn't do anything with the structure or financial plan or anything. And the client, next thing you know, a year and a half later, the client comes back to him and says, I'm out of money. Well, what happened? How did he blow $1 million? Well, Casino Morongo was picking him up in private cars and giving him suites and private tables and all this stuff. And next thing you know, he's done. And this was a obviously it was a life-altering injury with life-altering money. And he's back to square one a year and a half after the settlement. So that's a story I tell my clients, and I tell them, look, I know that's not you. I know that you're not going to do that, but that's the fear that's always in the back of my head. And the worst call I can get is, we've done a great job for people on a case, and then a year, 2 years, 3 years later, they call me and they say, hey, I'm broke. The other thing, in talking about the multiple players, what I've told my clients is like, look, when you come into this kind of money, people come out of the woodwork and they start coming and asking you questions. Hey, I want to start a business. Can I borrow 20 grand? Hey, my grandma's in the hospital. Can you give me, 10 grand for this? This is an easy way for them to have an out and say, you know what, my money's tied up. I can't get it out. I can only get X amount a month. So it gives them good excuse. So in me giving the clients that advice, you just put up the advisor slide. It's our job, right? Like it says right there, to use our independent professional judgment to advise our clients on what they should do. And so what we want to do, what I've done on the larger cases, is if my clients reject a structured settlement or working with a fiduciary, I have them sign off in writing that I've offered it to them, that they had a chance to ask as many questions as they wanted. They had a chance to meet with the planner, and they decided not to do it, because then, hey, if I get the call, it's, look, I tried. And it really is, I can't emphasize enough how much it really is in the client's best interest. We don't get anything out of it,
Yeah. So go ahead, Traci.
I would be curious how either one of you, because I have not found the perfect answer when I'm working with an attorney or having a conversation at a mixer, and they're like, it's not my responsibility. My responsibility, even though Pratik just kind of alluded to why it is, I'm still having a hard time, with that. I mean, how, if you were with a peer and they said, I just don't believe it's not my responsibility, do you have a word of advice that you would give them other than, yes, you should?
Yeah. I mean, this is how I handle it, and I talk about it. Let me take a step back first. The first thing that I'm mindful of is that I don't give financial advice, just like I don't give tax advice. I handle personal injury cases and some employment cases. You want a business litigator? I'm not the guy. Go find somebody else. you know, what we learn as young lawyers and as we practice, and Pratik, I'm sure you agree, is to kind of stay in your lane and understand what you're good at. I believe that you get yourself in a precarious situation if you're giving your client financial advice. However, this is not financial advice. So the settlement planner, the fiduciary, is giving the financial advice.
Yeah.
And this is what I call the handoff. And I use this phrase in my practice, and Traci, you and I have talked about it all the time, and we'll get to it when we get to the specific scenarios, is it's my job to hand the client off to the settlement planner. And I want to do everything in my power to do that. And I would advise any other attorney to do that. If my client is getting anything more than $150,000 of net, I'm having this conversation. Now, of course, the greater the value and the greater the money, the more serious I am about it. But we have a duty to protect our clients' best interests without giving them financial advice. And a settlement planner does that. And where this comes in the most for me is when I see the friends of the other client trying to get paid.
Yeah.
And how important it is that I am protecting them. You know, we all hear the sports stars, you know, I mean, Pratik and I might be aging ourselves, but I know he knows about, you know, Allen Iverson was, you know, this phenomenal basketball player getting all these contracts, and, you know, he was amazing. He was the answer. That was his nickname. And now he's broke. And he talks about how he had all these hangers on taking his money. Well, the same thing happens to our clients. Yeah. And when I talk about these things with other lawyers or young lawyers and groups I'm in, like the Orange County Trial Lawyers Association or Justice HQ, I talk about how important that this is part of your job.
Yeah.
And this
if I can just jump in there, Nick,
go ahead.
I just want to say one thing to add on. I agree with everything you're saying, and I just want to add on two things. One is I tell the clients, look, blame me, right? Yeah. I want to give the clients the ability to answer all those hangers on. Like, what is our client going to have to say? It's a tough conversation with them. I tell them, blame me. Tell them it's my fault. I don't care. My job is to look out for you. I don't care if your friends are mad at me. Tell them that it's my fault and that I'm kind of, this is part of the deal. That's number one. Number two is exactly what Nick said. It's part of our job. And to answer your question, Traci, is to the attorneys that are saying it's not my problem. Mm-hmm. Well, it could become your problem a year and a half, 2 years down the line, 3 years down the line. Maybe it hasn't been for 5 or 6 or 7 years. That doesn't mean it's not going to happen. Is when the client says, hey, you never even told me this was an option. You never even gave me the option. Well, what are you going to say to the client that says, hey, you knew this existed? You knew that financial planners and settlement structures and all this stuff was out there, and you never even told me about it? And now I'm broke? How are you going to answer that question? Well, that's a much tougher question to ask, or that's a much tougher question to answer than, hey, is it my problem? Well, yeah, I mean, theoretically, no, of course, nothing's really your problem if you want to go down that path. But the reality is it's a part of our job to advise our clients properly.
Well, what about this? I mean, what about the fact that our reputation, look, part of being a plaintiff's attorney, an injury attorney, or whatever we just consumer attorney, we don't have an insurance company feeding us work.
Right.
And I know Pratik well enough, and I know myself well enough. I'm not out there. I'm not a mill. I don't get, hundreds and hundreds of cases every month with a freeway sign. The vast majority of my work is through my reputation. I mean, your reputation means everything. And you want people out in the community saying, attorney, Mr. Shah, and he not only did he kick butt and got me a lot of money, he made sure that I was protected. I felt he was part of my family. And these are the types of things to do to get repeat business.
And I always think too is when if somebody said to you, hey, I need you to go back to your past clients and get me 10 testimonials, are you sitting there thinking, yep, boom, 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 I can call any one of them and they're all going to give me a great testimonial? Or do you have to pause and go, yeah, I'm not sure if they will, and that's just it, is you want to be comfortable that every one of your clients, and there's always a few quirky ones, but every one of your clients, are interested in that. I'm one of only 2 certified financial transitionists in the country. And what that is that's connecting the emotional side and the technical side. But I bring that up because the training came from the Sudden Money Institute, which was interesting is that with all of the NFL players, it's actually Sudden Money Institute helped to create that only CFPs can work with the NFL. Because the NFL and a lot of the other organizations, the athletic organizations, when you just work with any wealth manager or financial advisor, you're not getting the full picture planning. It would be great in my world if everybody had to work with a fiduciary, when we're working with the clients, just because of that. But it's interesting when you brought up the athletes athletes are one of the number one. I put settlement planning can be right up there with the statistics of people receiving money, because it's usually typically gone in 3 to 5 years.
Yeah.
All right.
Yeah.
So
I mean, I've seen it and I 100% agree with that.
I think it's a perfect segue into kind of our next topic. And Pratik, again, I'll fire a question off at you if you don't mind.
Sure. Hopefully I know the answer.
So I'm going to separate this into a couple of categories. So I'm going to ask the question and I'll divide the categories, and you just take one and I'll take the other, and we'll go from there. So
Sure.
The question is when do you get a settlement planner involved? So
great question. Yeah.
I think
go ahead.
Just to divide it up, I think let's talk about pre-litigation, pre-mediation, at mediation, and then the post after mediation and after settlement. So pick one and go for it.
Yeah. So I'll talk more in litigation. I don't handle the pre-litigation at my firm, so that's a little outside my zone. But what I do in my cases is once we're starting to get to a point where we can talk real numbers, if we've got a mediation coming up, or if I got a demand that I'm sending out, or a 998. But honestly, anytime I'm having a conversation with the client, if my staff has done discovery with them, and then they're always asking a question, right? We always get the same question from our clients. What do you think my case is worth? When do you think it'll settle? How much longer is this going to take? We've all had that conversation. As part of that conversation, I always start planting the seed and say, look, we got to do discovery. We're going to take some depots. They're going to take some depots. They're going to take your deposition. And then we can start talking mediation, and we can start talking numbers. And one of the people I want to get involved when we get to that point is a financial settlement planner. And I always get the objection, I don't know. And I said, look, you don't have to make any decisions now. But these are people you should talk to, just like we talk to other experts. But I want to plant that seed early so that there's not a wishy-washy down the line. Ultimately, unfortunately, Traci, if my client is, heart set on not having a financial planner because they think they're a genius, there's nothing I can do. They're going to sign off. That's all I can do. But, I plant the seed early because I want to protect my client. I want to protect myself. I want to protect my firm's reputation. All the things Nick mentioned and Traci mentioned, I want to start that early, because then when I go to mediation, I tell the defense, hey, we're not going to settle unless you guys are agreeing to a structured settlement language. This language has to be in the release. There's no discussions of settlement unless you guys can agree to this. And every time I've brought it up early, I've never had a problem. The only time I've had a problem is when a client has flip-flopped, and then we need to change the release language. And then it's now the insurance company sniffs out that they've got some leverage and they can get a little bit of a discount. But if we have the discussions early as possible, really, we have the discussions early. Once we know a sense of value, let's say we know that this case is, we've got an offer of $100,000 and we know the case is probably worth 250, 300. Okay, look, we know where this is going. Let's start talking numbers. Let me call Traci. Hey, Traci, if my client was to receive, $100,000, what does that mean for them? This is what their personal goal is. They want to buy a house. They want to do this. They want to do that. I'm not saying 100,000 can buy a house, but I'm just saying, like,
the Midwest.
Yeah. As an example, these are my client's goals with the money. And I think, I'm ranting a little bit here, but I think that's an important thing, is asking your client, what are their goals with the money? Because a lot of times our clients say, I'm not settling unless I get 200,000. Well, one, where did you get that number from? And why is that number so important to you? Okay. If 200,000 is important because you've got these plans, well, what if I get you 100, and then with Traci, she grows it to 200 or 250 or 300 over time? Does that help solve the issue that you have outstanding? So having these open and honest conversations with our client early can help resolve problems early and prevent problems, actually, more than resolve them.
Nick probably knows my buckets more than anybody. I have a handful of attorneys that I work with. It's when I work with clients, I put money in buckets. It's like we have to pay off debts because obviously you can have a credit card at 23% and then tell them to do a structured settlement. And then you really understanding whether their upfront needs are the needs or wants, making sure they have an emergency fund, and then it makes sense to bring me in. And so, Pratik, we're talking about like somebody with a 100. So many people would be like, "Oh, I only call people if it's over $1 million." I'm like, no. It doesn't. It really there isn't an amount. It's a case by case. If that particular client had $100,000 and really they didn't have any debts, they just needed a new car and that was it, and then they had a chunk of money left over. But on the very next client, they got $100,000. By the time you went through, well, we have 23,000 of credit card debt. We definitely need a new car. We have 0 emergency funds. Then that's not the client that you call a settlement planner on. So I think getting used to the buckets, if you will, of just organizing it. And literally that conversation is about a 10 to 15 minute conversation generally.
Yeah. So I agree with Pratik, but I think I look at it a little differently. And I think I try to think, I'm always thinking about this. It's why I have this gray hair, is because I'm always thinking. See that? I try to I agree in planting the seed early, but I guess to finish the analogy is that seed looks different for each case for me.
Yeah, definitely.
And you have to like evaluate that client, I think we all agree that if you start talking actual dollars too early, you are really doing yourself a disservice and you're backing yourself in, because what happens if your client just ruins his or her case in their depot?
Right.
You can't go say that to all of them.
Right.
Some of them you can, but most of them you can't. You just, that's part of my prep with clients and depositions is you don't win or lose this case here. Right. This is just another task to get through, even though I firmly believe you can lose your case in a depot.
Yeah.
I don't think you can win one, but I think you can lose one. So depending on the case, and I'm going to bring up a particular case that Traci and I worked on now. I had a case where it was he was in his 20s. Kid got beat up at a party, had a really bad brain injury, but he was just making bad decision after bad decision, pre, during, and post litigation even. And he had a lot of hangers on, including his mother, who felt that because she took care of him during the initial months after the brain injury, that she was entitled and wanted a significant portion of his settlement funds. And that's just not true. I mean, the mother is not the client. He was the client. And I was able to successfully, throw some distraction, because that's when I had Traci at mediation. And what Traci was able to do, and we did it, I mean, I don't remember. I don't think we talked about the plan beforehand. It just happened.
It just happened.
Yeah. And Traci saw, and I watched her do it. We were both like watching it happen. Is Traci took an opportunity to get the son away from the mother and it wasn't just physically, is that Traci was able to endear herself to the son. And then he in turn realized that she was someone she could trust. And up until this moment in this kid's life, he hadn't trusted anybody. And it was something that I dealt with early on in the case. So when he had gained he started to trust me. And then I said, look, I'm bringing Traci, talk to her. He wanted no interest. But what we were able to do is at that moment, I then was focused on mom, and Traci was able to get the kid in a good spot to understand the importance of a structured settlement. And he paid off debt and he structured the rest of it. And it's a story that I love to tell, because I was sitting at the under end of the table, and Traci and I think we like exchanged like a look, and Traci's like, hey, let's go. I think it was like, hey, let's walk outside for a minute. Right. And I knew because I trust Traci and she's a fiduciary and we've worked on stuff, what was happening at that moment. But there's other cases that I would never, ever have Traci at mediation.
Right.
She would be wasting her time.
Yeah, I
because the
think that's a
clients-
great point. 100% agree. It's totally case by case. You know, there's cases where it's appropriate and cases it's not. And I think that's a fantastic story because it shows the value of having your structured person or your financial person, Traci, as why it's important that they're a fiduciary and the importance of having them at mediation on the right cases. And that's another thing, you know, it's not just telling your clients about their financial person early or telling your clients about Traci early. It's about telling Traci about your clients early too.
Yep. Yeah.
So that, you know, look, she's busy and, you know, whoever the fiduciary is, ideally you'd be using Traci, but whoever the fiduciary is, you got to talk to them early. You can't call them the day before mediation, say, hey, I got this $10 million mediation going tomorrow. Can you show up? You know, knowing Traci, she's going to still show up, but you're making it hard on her, you know?
Right.
Thanks. Well, the trust is different for every single client. And this one that Nick and I talked about, I didn't say no. He wanted a $9,000 Cartier bracelet, and I didn't say no in the plan. And I think that's what worked. Is I wasn't shutting him down, but I did twist it to say, okay, if we do that, that's your one kind of blow. If we do that, you're going to wear it every day, and you're going to remember what you went through, the lessons that you learned. And every day when you wear that Cartier, you're going to remember good money management. And that client has been excellent.
Right.
Excellent.
So Traci, I know there's some specific things that I know I have. I can't list them all, but they all come up. Why don't we talk about some ABLE accounts and some QSFs? I think educating everybody on what those are and how those could help you would be good. This would be a good point to discuss those.
Yeah. So on one spectrum, you have a case that settles in and there's less than $15,000 and you have a disabled. And it's like, that is like the most horrific for a plaintiff attorney to deal with. You're like, it didn't settle. I have to go to court. I have to get approval. And, you know, what are some of the options instead of using the special needs trust? And, or as long as somebody's been injured or had, the disability prior to the age of 26, you can open what's called an ABLE account. It preserves the needs-based benefits that a client has, and it gives them some more flexibility. So there's little creative options like that. A qualified settlement fund is an amazing tool. It just has to be used appropriately. A qualified settlement fund is like an escrow account, if you will. It's where the defendant is done. You've got a lot of liens, you've got a lot of complications. The biggest thing is if you have more than one claimant, not from the same family, and you have allocation issues, it's a great holding place to have the funds go into it and then do the distributions, you know, on your own time, however the defendant's out. We've used this tool many times that we thought that the defendant was going to go bankrupt. And so just making sure that the funds are in, and then we deal with some of the settlement planning after. But I mean, we just have to make sure that all of the ducks are in a row before we do it. But that's another amazing tool that we can use. Many times I'm working on a slight TBI case, and I like the slight TBI, meaning major TBI, and in a coma for 6 weeks, bad case. However, he is good enough. He is actually working. He can function on his own, but some of his behaviors are not quite right. And so in that particular case, we're just using a regular living trust. And when you use a living trust, you can also bring in to have a co-trustee. So these are things that we're doing kind of on the backside, and working with your planner to kind of think outside the box. That's one of the things I love the most is like, give me a problem. I'm going to figure out a solution using some of the different tools, you know, as we go along.
So I think this is a perfect, well, you know, we have 15 minutes left. I want to make sure one of our attendees asked a question, and I want to make sure we get to it before I go to the next subject. Can you go deeper into the brain trust? Would love to hear more on that and how they all play together.
Yeah.
Go ahead.
Well, I would find different brain trusts. You guys have a brain trust. I have a brain trust, and they all kind of intermix. My brain trust consists of, because as a planner, I can't do everything. I'm very good at the first slide. Thank you, cat herding. I'm very good at bringing everybody together. but you can't do everything. And so my brain trust consists of, do you need a CPA? Do we need an estate planning attorney? Do we need a special needs trust attorney? Do I need a government benefits specialist? Do I need to do a Medicare set aside? And then there's an administrator for the Medicare set aside. You know, who are all of my people that I bring in post settlement and kind of herd them and get them together. And by the way, I feel your pain, because let me tell you, I bring in, if I didn't trust my trust attorney and they have a conversation that I wasn't involved with, the next thing you know, the client goes sideways. So no, I have a trust of people that I know that if I'm referring to them and they're talking to my client without me in presence, that we're all saying the same thing. And that's where a loyalty is super, super important when you're working with your settlement planner, just because you know each other, you know what you're going to say. Then whereas, your brain trust is a little unique. You know, you've got the life care planners and your economists and your settlement plan, you're bringing different trust. So I think it's important that that people bring, that's my definition of a brain trust, is bringing in the right people.
Yeah, I would just add my brain trust in every case. I mean, there's two, right? First, the brain trust is my partner, myself, my staff, how we handle a case. That's on the base level. Another step, Pratik is in my brain trust. We talk about cases all the time. Hey man, have you had this? Have you had that? I ask him, him and I talk about cases, if not weekly, monthly, what cases we have. And there's a group of us lawyers, we all talk about it. Then you have your experts on your case, and that's individual at each case. In this scenario, though, with the brain trust, it's more who the decision makers in my clients' lives.
Yeah.
And it's more for a bigger case. So I think, in a smaller case, I don't know how much I'm going to get everyone involved.
No, you don't need them. Yeah.
If I have life-changing money for this person, like I have a case that I'm thinking about right now that the client has been very hesitant, and I've tried to plant the seed about Traci. This is the brain injury, the tumor one, Traci, I've been talking about now for like a year. And he knows better, but he doesn't. He has a brain injury. And I've started now to plant the seeds with his mother.
Mm-hmm.
I've planted the seeds with his father. They're divorced, and now my client's a 35-year-old man. And identifying who are those people in your client's lives, it may be you. You may be this client's confidant. You're their attorney, but they need help. So it goes back to the first stage. The first thing I said to start this is identify the players and identify the priorities in someone's life, and use those to your advantage to get the client to understand the importance of settlement planning.
I agree with all that. And I agree with Nick. Nick's obviously in my brain trust as well. And, he's absolutely right. And just like we as professionals, as attorneys, everybody that's on this call or that's on this webinar has that group of people in their life, both professional and personal, that they rely on to do what's best for their clients and their family. And Traci's going to have the same thing, right? Like, we're all professionals, and we're all going to have, what's the difference between someone hiring an estate planning lawyer to do their PI case and hiring a PI lawyer to do the PI case? Well, the difference is, as a PI lawyer, we have a brain trust. We have doctors we know are good and that are going to write, what all the information we need in the reports, that are going to advise the client properly, that have good bedside manner. We have voc rehab experts we like, and life care planners that we've had experience with, that we know and trust. And then it's the same thing for every other professional that's out there. A person like Traci, who's been doing this and his experience, is going to have her team of people that she's worked with. She's, the people that she's had bad experiences with, she's done with now, right?
Right.
We all go through that. I've had sent my clients to a doctor. I'm like, I tried a new doctor that someone recommended. And I'm like, you know what? I like this other person better. I'm not going there anymore. So it happens. And over time, and that's why experience is so important, is because over time you realize who is your squad and your team that you trust, and that's going to take the client through the finish line so that they're happy and they can kind of go on to their new life.
So I hope that answers your question. And if you need more details, just type away in the chat and we'll get to it. So kind of last, as we're on the home stretch here, I think I want to start with Traci on this one, because she's probably got the best war stories out of all of us.
Yeah.
What are the biggest roadblocks or obstacles that you see Now, and Traci, I'd first like you to kind of what you see, not so much your roadblocks or obstacles, but what you see going on in the attorney-client relationship with these things in your experience.
Well, a couple of ways to answer that, and I'll try to keep it as short as possible. But there's a lot of roadblocks that I have just as in perceptions, and then I'll answer it a couple ways. Perceptions are the client's too old. I ask how old they are, and they're like, "Oh, they're 68." I'm like, "That's not old. It really isn't." And people are usually on that turn where they want things more conservatively. You can do structured settlements up to 83 years old. I get the client's too smart. They're fully educated. They're too smart. Just because you're smart doesn't mean that you have a high risk tolerance. And so I did a case, and of course I work on cases that you can do a structured settlement as low as $10,000. And then 2 years ago I did it where their net was 13 million, but they were frozen, and one's an attorney, one's a CFO, and neither of them had any risk tolerance whatsoever. So the annuity was kind of the right thing. Rates are too low. Well, they keep bouncing around, and I don't, at least for my business, I don't sell on interest rates. I have a conversation. I put a plan together based on the need, the emotional side of what makes you sleep at night. So that's super important. Or the biggest roadblock with attorneys is it takes too long. It doesn't really take that long. And you can touch back on that in your opinion in a second. But some of the roadblocks that I see that the attorneys have are some of the same ones. Is you guys are the first in line dealing with the client who has the family member that showed up at the last minute. Or the expectations of a case. From my view, one of the things that I think an attorney could do better sometimes is they don't set the expectations on what the demand is and what the real value of where you're starting. That's probably a big deal. It's like if we're starting at 9 million, why did we settle for 3? That's a big one, is just making sure that it's like, well, 9 million. And then it is hard to explain present value to some clients, but you almost want to do that. And I can help do that too. When I put plans together, it's like, well, that's not the real value in this particular case. So a roadblock an attorney has, I see in mediations a lot, is that is the expectations that the attorney doesn't know that they actually set up for the client. And so that's where we turn around and say, well, okay, if you have this and this and this, it's going to take care of these things. So that becomes a roadblock. The client understanding that there are two sides to everything in life, an emotional and technical side. So every now and then it's the attorney talking, just communicating. Believe it or not, I know it takes time. And that's why if you guys have great staff that'll do some of those conversations, that would be great. But the lack of communication, believe it or not, I see a ton of clients who are freaked out at a mediation because the attorney didn't tell them what to wear. Yeah. I hear that all the time. Yeah. It's just those little things. Where do I park? Do I eat there? There's just different things there too. But so I think that it's a trust with the relationship with the attorney to get to the settlement planner. And there's just odds and then roadblocks, but I think the roadblocks can all be taken care of if the client trusts the attorney. And that is building that relationship all along. So I kind of threw a few different things out there, Nick. I hope I answered your question.
No, you did. And the only one that I'd like to just chime in on is my biggest roadblock is honestly the idea of it. If I can get my client past the idea of it, it's a done deal. I'm like batting 1,000. It's that initial, I've never heard of it. I don't like it. I don't know what it is. I don't like it. Annuities, I've heard those are bad. Yep. Why am I giving control up to my money, to somebody else? If I can get them past that initial thing, then I'm usually home free. And it kind of goes to how I practice law is being prepared.
Yeah.
If I'm prepared and I have the right timing, and look, we all make mistakes, and there's plenty of cases where I've had where I'm like, shit, like I should have done this 3 months ago and it just slipped through the cracks, right? It happens.
Yeah.
If I'm prepared and I'm working my case up the way I want to, it's fine. And
one thing I'll jump in on what Nick's saying. I agree with them. I think that once we get past that initial hurdle, and I'll tell you this, it helps settle cases because you know what clients believe the value of the cases and what the actual value of the cases are often very different numbers. I would say all the time they're very different numbers. It's very rare where I've had a client say, this is what I think I want to settle for, and it's the exact number that I have in my head. That just doesn't happen, right? So what I talk about with my clients is money in their pocket, net, because that's all that really matters. It doesn't matter if we settle the case for 3 million or 2 million or 500,000, as long as the money that they need to reach their goals is what they're getting. And when I can show them that, once we get past that hurdle that Nick is talking about of why a fiduciary is important, why this is important to at least consider and discuss, once we get past that hurdle and Traci's at mediation and we're talking numbers, and you know, my client's there and my client's saying, well, you know, this is my goal, blah, blah. Okay, well, you wanted 500,000. You know, that's not really the value of what your case is. The value of your case is a little bit lower, but in your pocket, you wanted, you know, 300. Well, we can get you 200, but it'll turn into 300 because of what Traci's going to do, and you'll still be able to reach all your goals. That helps close cases for what they're worth instead of dragging cases out because we need to get an extra 25,000 or 50,000. Because the client can still get what they're supposed to get and what they want and the goal they want to reach. We just use different tools to get there.
Yeah, I think that one of the things where you can really, really utilize your planner that a lot of people don't use is on the backside. A lot of times they haven't had the conversation with you or the attorney, or I have to tell you, they do think that attorneys walk on water. And I think that that's fabulous if you have that relationship. But with that said, sometimes they won't be as vulnerable with you as they might be with me. So when I'm having a conversation with a client, many times in advance, this is why you would want to bring in a planner early, is setting expectations. And of course, you have to have the relationship with your planner to know that they're not going to say anything. And so a lot of times I will have a conversation and I call the client, you introduce, say, hey, Traci's going to call you. She crosses the T's, she dots the I's, and you don't have to say she's going to deal with the money. She's part of the team. She's part of our brain trust. And so when I call them, I do not say immediately that I'm the financial person. I say I am a settlement planner and I have two roles. My first role is to protect any needs-based benefits that you're on. And so I've also done that checklist for the attorney, checking all of those things up. And that's a warm lead for the client. And so when you're introducing a planner, set them up as a settlement planner, helping you to make sure that everybody's protected during the settlement process. And then I say, and then my second role is if there's some settlement funds, I'm here to talk about the different options that might be available. 99.9% of the time, I get the buckets before you go to mediation. And I can tell you, if you can get them this amount, I will cover their debts, I will take care of their immediate needs, I will take care of their emergencies, and this is above and beyond. I can give you the number that will emotionally settle the case.
Yeah. And that's huge. And that's huge, having that info going in.
So we don't have any more questions. So I'm going to ask you guys a question the last one here. 30 seconds or less. I'll start with you, Pratik.
Okay. Pop quiz,
30 seconds or less. If you wanted to instill or impart one piece of information about this topic to our attendees, if they take one thing from this hour, what do you want that to be?
Trust. You need to trust. You have to trust your experts, and having the right financial person in there is part of that. Your experts are not just your doctors and your liability experts. This is your financial expert is part of that process and part of that portfolio. Your clients trust you. And when you tell them, hey, trust me, you need to talk to this person. This is someone I trust. That's going to transfer over nicely. So the key word for me is going to be trust all around.
How about you, Traci?
I actually just want to mirror what Pratik said, because that
happens to him often.
I mean, that is exactly what it is the client's going to trust the person that the attorney trusts too. And again, if you ever get to a place where they're not trusting and you've done everything you can, always remember that there's disclaimers. You can talk to your settlement planner, have them sign off a disclaimer. I don't want an annuity. I want to screw my government benefits. I don't want a Medicare set aside. You can do a disclaimer, but I literally just want to, say thanks, because that's exactly what it is. And of course, I always tell everybody, don't sign the release. Call your planner before you sign the release.
Yeah.
That's always my extra disclaimer.
Yeah, so mine would be, I guess I get two since I'm asking the questions. My first one is just to expand on that. Trust, I would say, also a tool.
Yeah.
Like your computer and your court reporter and your biomechanic and all the different things that we use to litigate or work up our cases. A settlement planner is just as important, if not more important, than all of those together.
Yeah.
And knowing, we all have different schools of thought and we're taught different ways. When do you call the biomechanic? When do you get the ortho? When do you get the neurosurgeon? When do you get this expert or not? It's the same thing, and you got to know when to use it and when not to. And the second thing is, and this is a little one, every time I settle a case at mediation, even if I haven't even thought about it, I put in that stip at Judicate West. Plaintiff reserves the right to structure the settlement every single time. I personally would argue that it's malpractice not to, because you have to have that option. At least, even if they've shot you down to date, have it one more time. And then now you've done what you can. Thanks everybody. Thank you, Traci.
Yeah,
Pratik.
no, thanks for being there
guys.
too. And
thanks for having us on.
Of course, I'll send a follow-up with everybody's contact information as well. And so, I think that if I can speak for the two of you, you guys are such advocates for just education and helping, that anybody that's listening that wants to call you guys just to talk about any of these subjects or anything else, I'm sure that you're open to those phone calls.
Of
Yeah,
course.
Absolutely.
Okay. Thanks for having me.
I'm gonna go for a swim, so I'll see you. I'll see you guys later.
I love it.
Care. Thank
Thanks,
you.
guys. All right. Bye-bye.